This is Washington Watch with Tony Perkins, your daily voice in Washington, D.C. on issues of faith, family, and freedom. And now, here's your host, Family Research Council President, Tony Perkins.
Hello and welcome to Washington Watch on this 26th day of June 2013. The U.S. Supreme Court handed down their two decisions on marriage this morning in U.S. versus Windsor. In that case, the Federal Defense of Marriage Act, or DOMA, the court ruled the federal statute invalid, forcing the federal government to recognize same-sex unions in the 12 states that currently recognize same-sex marriage. In the California Prop 8 case, California's marriage amendment, the court said those defending the amendment did not have standing, which put the California amendment possibly on the path to being overturned. There's more to that story. We'll get to that later. Now, what do these opinions mean for marriage and family in America? What do they mean for your family? What does it mean for religious freedom going forward here in our country? Will today's decisions from the court set up further attacks on the institution of marriage? And does Congress have the authority to act? We'll answer those questions and more today as I'm joined later by Pennsylvania Congressman Joe Pitts, chairman of the House Values Action Team. I'll also be taking your calls later in the program, 888-589-8840, the number later in the program. You can also send me a message right now by going to tonyperkins.com. Click on Email the Show, and you can send your questions or comments to that through that means. Well, joining me now as we jump right into our analysis of today's decisions is Ken Klukowski, one of our attorneys who was at the Supreme Court today when the decisions were handed down. He serves as our director of the Center for Religious Liberty at the Family Research Council. He is also a contributor to Breitbart.com. Ken, welcome back to the program.
Thanks for having me, Tony.
All right, let's start. Two decisions handed down today. Let's get a quick overview. One dealing with the Federal Defense of Marriage Act, and the other with Prop 8 out of California.
Well, that's right. With the Prop 8 out of California, there's been a lot of misreporting on what's going on with that. Media accounts are saying that Prop 8 was struck down, or more specifically, that the Supreme Court threw out the appellate stuff and left in place a district court ruling, striking it down. That is not correct as a matter of law. What the Supreme Court said is that the plaintiffs in this case they sued the state. And that means that the governor and the attorney general have to defend. The California governor and AG violated their oaths of office and said, we will not defend our state constitution, defending marriage as one man and one woman. That was litigated before Judge Vaughn Walker, a U.S. district judge, and he held that it is unconstitutional, that Prop 8 is unconstitutional. At that point, when, again, the state refused to defend it, they also refused to appeal it. At that point, the defenders of the case, the official sponsors of Prop 8, who had litigated for it. Those that helped
pass it.
That's correct. That's correct. Who were involved in the lower court lawsuit, so they litigated it. They filed the notice of appeal, took this up to the Ninth Circuit Federal Appeals Court, then to the Supreme Court. What the Supreme Court held today is you cannot do that. That the federal courts do not have jurisdiction to allow outside third parties to come in and file notice of appeals to step into what the state court
So
did there.
Bottom line is that the governor, the attorney general in the state of California refused to live by their constitutional oath of upholding the Constitution, the actual Constitution in the state of California. Therefore, no one was there to defend it, and outside parties were not allowed.
That's correct. Now, the Supreme Court therefore said, we have no jurisdiction, so we're getting rid of the case. The Ninth Circuit Appeals Court had no jurisdiction, so we're vacating, we are striking down their order, which spoke about a constitutional right to gay marriage. Now, that did leave in place Vaughn Walker's opinion. However, it's recently come out, and I'll have a piece out later in the next few hours explaining this in more detail. The California state constitution specifies that if a matter is enacted as law, either through the legislature or through the referendum process, and of course Prop 8 was a ballot proposition, that all state agencies must regard it as constitutional until an appeals court tells them it's unconstitutional. Von Walker is not an appeals judge, so there is no appellate opinion on the books now. Since the Supreme Court got rid of the Ninth Circuit, there is no appeals court opinion right now saying that Prop 8 is unconstitutional, so it is still on the books, valid law in California as of this moment.
So where does that stand then when there is a conflict between a federal district judge, which that's what Von Walker was, and a state constitution here saying that this is still valid until it is overturned by an appeals court?
Well, the federal court does have the power to trump state law, including the state constitution. However, you still have the state constitutional provision, so anyone who is adversely affected in California right now would have standing to file a California lawsuit saying, to my understanding of the law, this is still on the books. Now, maybe at the end of the day, maybe California courts would agree and strike it down. But the reality is that's what courts are for. I think we're looking at new litigation, possibly months or even years of new litigation.
So you're listening to Washington Watch. I'm your host, Tony Perkins, joined by Ken Klukowski, an attorney here at the Family Research Council who was in the Supreme Court today as they handed down this decision. So it's been hard to hear what's actually taken place through all the celebration that's been going on by those trying to redefine marriage. But here's the bottom line. Out of California, Prop 8, the court did not say that was unconstitutional. They simply said those who were there defending it had no standing, and they sent it back.
That's right. The U.S. Supreme Court said nothing to suggest that Prop 8 was unconstitutional. And in fact, switching over to the DOMA decision, that's the one encouraging part of the DOMA decision, is that, which was a 5-4 decision, which we can unpack, but to jump ahead to just a part of that, Justice Kennedy, writing the 5-4 decision against DOMA, went on for 7 pages talking about how states do have legitimate interest in defining marriage for the purposes of their own states. In what is sure to be follow-up legislation, we can very much hope and pray that Justice Kennedy stays true to what he said. And even if he is saying that the federal government cannot make laws defining marriage, that nonetheless he will respect we the people. He will respect what the voters do at the state level in terms of defining marriage as one man and one woman.
Folks, you're listening to Washington Watch. I'm your host, Tony Perkins. I'm joined by Ken Klukowski, and you're hearing something here that you've probably not heard on other media sources, and there's a reason for that. There is a line that the media, Hollywood, the prevailing elite culture wants you to believe that this is inevitable, that the court, in a sweeping decision today, paved the way for same-sex marriage. They did not. Now, I'm not going to candy coat this. This was not a good day for marriage, but all is not lost. Now, Ken, let me be very clear on this. Ted Olson and David Boyce went to the Supreme Court to seek that court to impose a redefinition of natural marriage on the nation. They did not get that. They did not come to Washington to see the court punt on this issue. They did not get what they want. They failed in what they were trying to get.
That's exactly right. They did not come all the way to the Supreme Court to have the Supreme Court say that they didn't have jurisdiction to decide the case. They were looking to have a broad national ruling. They wanted the court to declare that the 14th Amendment to the U.S. Constitution has an invisible, previously never-before-seen right to redefine marriage for any group of people to marry anyone they consent to marry, which, as we've said here before, would not just be same-sex marriage. There's no way you limit that to 2 people. If marriage is whatever adults consent to enter into, if they say, I love this person, I want to marry them, where do you get the number 2 there? If you can let any 2 people get married, then you can let any 3 people get married. All of those doors would have been opened if they had gotten what they wanted. They did not get that from this court.
Well, that's a very good point, Ken, because I even heard, as I was doing media this morning, and David Boyce was on the steps of the Supreme Court talking about this. He said, this has secured for Americans a fundamental right to marry whom you love. That you can marry the persons you love, and he used the plural there, the persons, because if any couple can get married, why not triples? Why not 3 people? Why not 4 people? There are actually those clamoring for that right now.
There certainly are, and the reality is the only reasons that are brought up, they say, well, we know that historically polygamy can be used to victimize women. We know that children might be abused in a polygamous setting. Okay, what about 3 men who want to get married? There's no woman to get abused in that relationship, and of course, in terms of natural procreation, there won't be any children either.
If you follow this line of reasoning that you should be able to marry whomever you love, then how do you draw the line at two persons?
Well, that's exactly right. As a matter of constitutional law, there would be no way to draw it. It could be one man with multiple women. It could be one woman with multiple men. It could be multiple men with multiple women, or it could be multiple people all of one sex. If we open the door to this, if, as you said, it's just a person can marry whomever they say they love, well, there's no number in that definition.
Right.
It's you can say, I love two people, and we all want to marry each other.
And folks, why this is important, what we're talking about here, is that as you've probably heard from other news sources, they've declared victory in California that Prop 8 was overturned. It was not. It was sent back simply because those defending it did not have standing. And as we are now combing through this, talking with other attorneys involved in the case, it does appear that the marriage amendment there in California, Prop 8, still has life. And even though there are those elected officials who may ignore it and start issuing marriage license, they would do so illegally. Here's why this is significant. As I said, Ted Olson came to Washington not to see the court punt on this issue, but to impose upon the entire nation a redefinition of natural marriage. That did not happen. They'll have to come back another day. Now, we'll talk in a moment about DOMA, and that could very well put down some stepping stones for them to come back to the court to redefine marriage. But here's something very significant. Time is not on their side. And you say, wait a minute, that's not what the media says. Well, you can't believe the media. Time is not on their side. Why? Because as Americans begin to realize that there's more attached to same-sex marriage than simply two people loving each other, the fact that we're talking about parental rights being lost, children being taught in the schools values and morals that run counter to what their parents are teaching them at home, when you begin to see the loss of religious freedom, when florists, bakers, photographers, and others are forced by the force of government to participate in same-sex marriage or be sued and even be placed in jail, people begin to realize there's more attached to this than simply two people who love each other. When churches and religious organizations lose their tax exemption for not participating in same-sex unions, people realize there's more attached to this than simply two people who love each other. Time is not on their side. I believe when Americans see this, they'll say, you know what? We didn't give a nod of affirmation to all of this. We just thought it was two people who loved each other. Time is not on their side, and it's going to be very important in the days going forward that these stories, parents losing the ability to teach their children and instill in them their values, those stories got to be told. The florists, the bakers, the photographers that are being threatened with lawsuits and threatened with jail simply because they would not participate in same-sex marriages. Those stories have to be told, and the media is not telling them. That's why you've got to be connected with organizations like FRC, American Family Radio, and be a listener to Washington Watch. Go to the website, TonyPerkins.com. On the other side of the break, Congressman Joe Pitts of Pennsylvania is going to be joining us to tell us what Congress might do in response to these decisions. Ken's going to be sticking around as well. We're going to continue our analysis, turning to DOMA and what that means for marriage going forward. Don't go away. We're going to be back with more Washington Watch right after this.